Story time again, it's about property this time. And it's another Western Sydney property story. But this one's not worth billions of dollars, it's worth tens of millions, I think. So Mum lived out Western Sydney on a big block of land on a main road. Over time, urban crawl meant that Mum now owned a block of land that a lot of developers wanted to build on. But the two sons were pretty wealthy and okay at property development, so they thought they were going to have a go at it. The problem with developing property is that when you go from holding it long term to then saying, I'm going to build some houses on it and flip it for the biggest amount of money that I can, you may have a business. And if you become a business and use an asset that was previously a capital asset, there's a special CGT event called CGT Event K4. K4 basically says when a CGT asset starts to become trading stock of your business. And also this was a main residence, so we wanted to maximize the main residence exemption. But we'd also like to get that 50% discount as well if we could. Mum was completely uninvolved in the development. She just wanted a new house to live in on the same land. So what we did is we struck a joint venture agreement. Mum would hold the land and would profit somewhat from the development, and the sons would do everything else. So they would get the DAs, they would lobby the council, they would do the plans, architecture, bank loans. They got power of attorney to do all of those things in her name as well. So she literally did nothing. All of these kinds of cases hinge on, is it capital or is it revenue? And in this case, it was whether Mum was going to get a 50% discount or not on selling the land. It was about 36 or 39 townhouses or something. One of those edge cases where we thought about a ruling and we pushed for a ruling, client decided against it, because if the ruling was negative, then the development would not be as viable. Regardless, we did something called a reasonably arguable position paper, which is a big old paper that I write for you, explaining why treating it as capital in this case would be a reasonably arguable position, and it protects you from audit penalties and interest. Practically, it also gives you all the ammunition you need, you'd think, to fight an audit from the ATO. And if there's one thing the ATO likes to audit, it's Western Sydney property transactions where people make lots and lots of money. These people never did get audited in the scheme of things. They probably should have, but they never did. So that wrap was just kept in the drawer as the insurance policy, and everyone went on to make lots and lots of money. Great ending on that one, I guess.